Today, we're moving on from annulment and going to be covering divorce grounds and procedure. Divorce, also known as dissolution. So, this chapter covers an introduction of divorce, no fault grounds for divorce, also fault grounds for divorce, legal separation, which we'll extensively cover next week, a separate maintenance, introduction to divorce procedure, covering domicile, full faith and credit clause, which we've heard of in previous weeks, divisible divorce, jurisdiction, venue, summary dissolution, pretrial matters, trial, alternative dispute resolution, which we've also covered briefly during the week on ethics, divorce judgment, enforcement of a divorce judgment, and then finally, we'll touch on religion and divorce procedure. So, what we know as a divorce or a dissolution is a declaration by a court that a validly entered marriage is terminated so that the parties are no longer married to each other. It is also known as a dissolution, a marital dissolution, or a divorce of vinculo matrimoni, or a divorce from the chains of marriage. So there are three main eras of divorce. The first era being era of restrictive divorce, where fault grounds were predominant. One party had to have been blamed. There had to be proven fault, corroboration of that fault, and a strong emphasis on morality, the courts meddling on what's right or wrong, heavily focusing on adultery, cruelty, and abandonment. Next is the era of collusive divorce, where a large number of spouses were lying to the court just so that they could establish the fault grounds to get divorced. Lying was the easiest way to get around the often extensive task of proving whose fault caused the marriage. So during the era of collusive divorce, we had both parties actually working together to lie, either both lying, one of them lying, to establish fault grounds so that they could get divorced. We're now in the era of unilateral divorce, meaning one party can initiate the divorce on no fault grounds, allowed by one spouse, again, to bring about the divorce decree. So we've moved away from restrictive divorce and kind of as a solution to all the lying during the era of collusive divorce, have established now what is known as a no-fault divorce era, where either party can initiate the divorce, in many cases not having to prove any fault whatsoever. Now, simply because a divorce can be a no-fault divorce, such as in California, we do not require the establish or proof of divorce on either party. That doesn't mean that fault is completely useless in determining or making other determinations. For example, no fault evidence is sometimes similar to evidence for fault grounds, which can be brought up in proving economic fault. So, in determining later on property division, each spouse will have to describe the situations that have led to dissipation or one party improperly obtaining community property and saying that it's separate property. So while the fault may not have been needed to establish grounds for a divorce, it is going to be brought up in terms of determining property distribution. Additionally, fault may be brought up in terms of awarding child custody disputes where parental misdeeds or faults, issues of fault could be relevant to child custody disputes. So perhaps one parent has a heavy drinking problem or a heavy gambling problem. While these aren't necessary grounds to establish cause for divorce, they definitely will be considered in terms of determining child custody disputes. So again, no fault divorce doesn't necessarily mean the absence of fault in determining other issues related to the divorce. So we're going to cover the main grounds for divorce. Under the no fault grounds, the main ones that you'll see or hear about are the grounds of living apart, incompatibility, and irreconcilable differences. So I just wanted to briefly refer you to the modules where I have included the family law code, which delineates the grounds for divorce in California. Oops, let me see if I can minimize this. Okay. So, grounds for dissolution or legal separation in California. Dissolution of the marriage or legal separation of the parties may be based on either of the following grounds, which shall be pleaded generally. A, irreconcilable differences, which have caused the irremediable breakdown of the marriage, meaning it cannot be reconciled or fixed, or permanent legal incapacity to make decisions. So those are the two main grounds to obtain a divorce in California: irreconcilable differences or permanent legal incapacity to make decisions. So the statute or the code further describes irreconcilable differences as those grounds which are determined by the court to be substantial reasons for not continuing the marriage and which make it appear that the marriage should be dissolved. Now, it goes on further to say a marriage may be dissolved on the grounds of permanent legal incapacity to make decisions only upon proof, including competent medical or psychiatric testimony, that the spouse was at the time the petition was filed and remains permanently lacking the legal capacity to make decisions. Finally, note dissolution of marriage granted on the ground of permanent legal incapacity to make decisions relieves the spouse from any obligation imposed by law as a result of the marriage for the support of the spouse who lacks legal incapacity to make decisions, and the court may make an order for support or require a bond thereof as the circumstances require. So if a divorce is ultimately obtained by subsection B, which is a permanent legal incapacity to make decisions, that doesn't free the spouse who does not suffer the legal incapacity from having to potentially award any support or pay any support to the spouse who does lack that legal capacity. Okay, so again, we just discussed the main grounds for divorce in California. So we discussed irreconcilable differences. The other two no-fault grounds are living apart and incompatibility. Living apart will sometimes also be called living separate and apart, where parties do not have to prove that one of them was in fault in causing the separation. For states that do require or do offer the ground of living apart, California does not. They make sure you read to see if the statute specifies a specific time frame. Most living apart statutes will require that the parties intend to end their marriage when they live separately for a designated period of consecutive time. So they have to have lived apart, usually in different buildings. So depending on what state, you'd have to read the statute to see if it would count if, let's say, a husband and wife are living in separate rooms but under the same roof, if that will satisfy the element of living apart. Also, the time frame, they have to have lived apart generally between 6 months and 3 years, depending on the code of that state. It has to be a consecutive amount of time living separate and apart, so they can't be on again, off again, which also includes engaging in sexual relations. So that even if they live apart in separate houses, even separate cities, but yet once in a while they decide to engage in sexual relations, that would break the consecutiveness. Some states will even require a consent where both parties have to consent. So if one spouse is in the military, or if they're hospitalized or incapacitated for an extended period of time, that would not suffice for the consent requirement if consent is an element in proving that the parties were living apart. Now, in terms of incompatibility, this can't just be, frequent bickering and quarreling where they have some minor disagreements and they just, they're just not a match made in heaven per se. For most states that do have this ground, California does not. Fault is not an issue, but the plaintiff will have to establish that it does rise above more than just petty quarreling here and there. Now, what about do both of the parties have to agree that it's impossible to live together? Not necessarily. If one party absolutely disagrees and flat out refuses to attend marriage counseling or mediation, then at that point, it's obvious that it'll be impossible for the two to continue if one of them is completely at an impasse. So again, California doesn't offer the ground of incompatibility for divorce, but for those that do, it is the impossibility of two parties being able to continue to live together in a normal marital relationship. We just covered irreconcilable differences. Again, it's basically stating that there's such discord between the husband and wife that there has been an irremediable breakdown of the marriage where it cannot be salvaged. Ultimately, the courts in that situation will leave it up to the parties who base their divorce on the central question of whether or not it makes sense to continue this marriage. If the answer is no, then they could easily cite irreconcilable differences. Now, most states offer a no-fault divorce, but it's important to understand the major fault grounds for states that do implement fault. The three major fault grounds are adultery, cruelty, and desertion. So, adultery is voluntary sexual intercourse between a married person and someone to whom he or she is not married. So, under this definition, one could interpret it to mean it has to be, sexual intercourse, but many states will specify or further describe this to include any kind of intimate relations between a married person and somebody else. They'll also further describe that somebody else, they could either be married or unmarried, any gender, it doesn't matter. These all fall within the spectrum of adultery. Now, it's rarely enforced, but adultery can be considered a crime in several states. Misdemeanor crime, although this is usually not enforced, because as we learned about Lawrence v. Texas, the courts have decided to stay out of the private, intimate conduct between two consenting adults. Now, cruelty is it results to basically what is considered extreme or inhuman treatment of one party over the other. Now, it's not enough that it's just frequent nagging or a good deal of arguing, but you would, in this situation, to allege cruelty, they would have to prove that it's extreme or inhuman or indecent. It's rise to the level of indecency. Some courts have required there to be proof of actual physical violence, which I think is ridiculous personally, but some states tried to rectify this by saying, okay, mental anguish will count for proving cruelty in a fault divorce state, but the mental anguish has to be coupled with some kind of physical symptom. So loss of sleep is a physical symptom as a result of mental anguish. So cruelty can be another grounds for divorce. But it's important to note that this means producing some kind of physical harm as a result of that cruelty. So desertion is a third major grounds for divorce in fault states. It's also known as abandonment, which occurs when one spouse voluntarily leaves another for an uninterrupted period of time with the intent not to return to resume cohabitation, and when the separation occurred without the consent of the other spouse and there was no justification or reasonable cause for the separation. So there's quite a few elements that you would need to prove to obtain a divorce using the desertion grounds. As we mentioned in the week on annulment, this kind of covers, this includes what is known as the Enoch-Arden divorce or Enoch-Arden presumption, where in certain states, a spouse's unexplained absence for a designated number of years is a ground for divorce if there has been due diligence in the search for the missing spouse and a belief that he or she is dead. So that's how some states have tackled desertion of one spouse. Now, other grounds that we've covered last week, just I want to mention again, they also can be grounds for annulment, but are mentioned in this book as well: bigamy, impotence, non-age, or being underage, fraud, duress, incest. So these are some of the other grounds that were raised in annulment as well. Okay, so we did cover the no-fault divorce grounds: living apart, which is living separately for a designated consecutive period of time with the intent to end the marriage. Incompatibility, which is the impossibility of two parties being able to continue to live together in a normal marital relationship. Irreconcilable differences, which is the no-fault grounds in California, where there's such discord between the husband and wife that there has been an irremediable breakdown of the marriage. Again, fault grounds for divorce: adultery, cruelty, desertion or abandonment, bigamy, being married to more than one person. Impotence is also a ground for divorce, which could be also avoidable ground for annulment, non-age, fraud, etc. So what are the defenses that can be brought to fault grounds? So let's say one party alleges adultery. They can raise any of these defenses: collusion, connivance, condonation, recrimination, or provocation. So it's important to note that less states are implementing fault grounds for divorce, so these defenses are being less and less used, but it's still important to know what they are. So collusion is an agreement by spouses that one or both will lie to the court in order to help secure the divorce. So the lie obviously has to pertain to the grounds for the divorce or to procedural requirements for obtaining divorce. So for example, one of them will lie about domestic violence, or they lie about whether they're domiciled in the state so they could obtain the divorce in that state with weaker requirements to obtain a divorce. These would fall within collusion. Now, in connivance, for connivance as a divorce or as a defense to fault grounds, this is a willingness or a consent by one spouse that a marital wrong be done by the other spouse. So, for example, hiring a third party to seduce their spouse, or knowing that their spouse is inclined to commit a marital offense but doesn't do anything to stop it. The main difference between connivance and collusion is that conniving covers conduct that was actually committed. There was an actual act that was done, whereas collusion is an agreement to lie and make up facts. Condonation is an express or implied forgiveness by the innocent spouse of the marital fault committed by the other spouse. So, for example, one spouse knows that their wife cheated on them, but continues to live with them, even though they're fully aware that they had cheated. So that would be kind of a ratification or condonation of that act. So keep in mind that this can be express or implied. They don't have to straight out say, "I forgive you." It could be implied by their actions. Recrimination is a serious marital wrong committed by the spouse seeking the divorce, even though the spouse is charging the other spouse with committing a serious marital wrong. So, for example, one spouse brings an action for divorce on the grounds of cheating or adultery, even though the plaintiff has also committed adultery. So, in this situation where both spouses are guilty, some courts won't allow either spouse to obtain a divorce. Other states will apply the doctrine of comparative rectitude, which would award the divorce to the spouse least at fault. So they would have to engage in major fact finding there to ultimately decide who's less guilty. And then finally, provocation is inciting the conduct that constitutes the marital wrong by the other spouse. So provoking them to engage in the fault ground. So there are two types of separation that exist when parties are having marital strife. So let's say they're not ready to obtain a divorce for whatever reason. They can either have an informal separation or a legal separation. So we're going to talk about here a legal separation, which is a declaration by a court has to be involved in this situation, that parties can live apart even though they are still married to each other. This is also known as a judicial separation, a limited divorce, divorce in mensa et todo, and separation from bed and board. Okay. So parties who are subject to a legal separation are not able to remarry. They're technically still married until it's dissolved by either one of the party dying, by annulment, or by later obtaining an absolute divorce. So why would anybody obtain a legal separation? It could be for religious or family reasons. I'm concerned about how the children will react to a divorce if it's small children. They may not wish to end the marriage by obtaining a divorce because of religious reasons. They may look down upon by their church, or it's not allowed in their religion. Um, Perhaps one of the parties has excellent health care that the entire family is on, and by terminating or by divorcing, it would terminate health care to the spouse. Um, they also might also know that they're in a bad place right now in their marriage. It's healthier for them to separate, but they're just not emotionally ready to divorce yet. When a court does grant a legal separation, it's also able to make rulings on spousal support, property division, child support, and child custody while the spouses are living apart. Later on, your first written assignment will be drafting a separation agreement, which is a private contract between a husband and wife who have separated or who are about to separate that will cover support, custody, property division, and other terms of their separation and later possible divorce. It's important to note that the date of separation is extremely important in separation cases um, because it'll determine whether property is classified as marital property or as separate property. We'll cover that next week. Now, separate maintenance are court ordered spousal support while the parties are separated but still married. It's also known as separate support or alimony without divorce. So, again, um, legal separations can um, while a party is legally separated, there can be spousal support awarded even though the parties are still married but they're separate. We're now transitioning to divorce procedure. The overwhelming number of divorce cases are uncontested because the other side either doesn't show up in court or doesn't dispute what the person for divorce is seeking. Oftentimes, spouses have negotiated an agreement either on their own or through obtaining an attorney on the termination of the marital relationship, alimony, property division, child custody, and child support. In these cases, divorce procedure is often really easy. In order to obtain a divorce, one or both parties must have a domicile in the state and be a resident of the state for a designated period of time. Unfortunately, it's easy to get mixed up between residence and domicile. So, what is a residence? A residence is a place where someone is living. A person can have many residences, so they can have a home in the city, plus a beach house, and an apartment in another state or country. Domicile, on the other hand, is a place where a person has been physically present with the intent to make that place a permanent home or with no intent to make any other place a permanent home. It is a place to which one would intend to return when they're away. With rare exceptions, a person can really only have one domicile. It's important to know where a person's domicile is. Two main reasons why a court will not have divorce jurisdiction to dissolve a marriage unless one or both spouses are domiciled in the state where that court sits. So we'll talk about in rem jurisdiction, which is a requirement to dissolve a marriage. Also for liability and estate tax purposes. So liability for the estate tax might depend on the domicile of the decedent at the time of death. So that's important to know for estate tax purposes. For children, they're going to, by operation of law, their domicile is established by their parent until they are either 18 or legally emancipated, at which point they can establish their own domicile. So in terms of children, whatever their parents' domicile is will be their domicile as well until emancipation or until they're 18. So we discussed full faith and credit in previous chapters. As a reminder, it's the obligation of one state to recognize and enforce the legal decisions of another state. This obligation is based on the U.S. Constitution, which provides that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. So full faith and credit as it relates to divorce basically states that the enforceability of a divorce order will depend on whether the court had proper jurisdiction to issue that order. So there are 5 possible orders of a divorce decree, each of which has to have been enforced and decided upon in a proper jurisdiction in order to be issued. Now, if for whatever reason that order was failed to be issued in the proper jurisdiction, at that point, the new state, forum state, will not have to implement the decision of the state where the divorce was initially issued. So a divorce judgment can consist of 5 major orders. First is which dissolves a marriage. Second is the order to award spousal support or alimony. Third is an order to divide the marital property, also known as property division. Fourth is a court order to award child support, and fifth is a court order to award child custody. So these are the 5 major orders that can potentially be included in a divorce judgment. So before we get into the different types of subject matter jurisdiction, I want to point out that there are 2 broad definitions of jurisdiction. The power definition, which is the power of a court to act in a particular case to resolve a matter, which does include subject matter jurisdiction, in rem jurisdiction, and personal jurisdiction. The second definition is the geographic definition of jurisdiction. So the geographic area over which a particular court has authority to power. We're going to be talking about the first definition, which is the power definition of jurisdiction. So subject matter jurisdiction is the court's power to resolve a particular type of legal dispute and to grant a particular type of relief. So in California, there are family courts in select areas of the state, as we know, that have subject matter jurisdiction over all issues related to family law. In rem jurisdiction is the court's power over a particular res or a thing, which could be land, or a status located within the territory over which the court has authority. So in rem jurisdiction, as it relates to family law, involves the court's power over a particular res, which is a status of marriage. Now, a court must have in rem jurisdiction to dissolve the status of marriage. If it does not have in rem jurisdiction, the court cannot issue a dissolution of that marriage. In rem jurisdiction is acquired by the domicile of one of the spouses, at least one. Personal jurisdiction is a court's power over a person to determine his or her personal rights and duties. A court must have personal jurisdiction to order alimony, child support, or a property division. Personal jurisdiction is acquired by service of process or by the long-arm statute, also by consenting to be served in that jurisdiction. So again, to acquire personal jurisdiction, one has to either be served by being physically present in the state. So in order to be served in that state, they have to be personally delivered the complaint or the petition and summons within that state. If they are not personally served within the state, they can consent to being served in that state. So a defendant can agree to be subject to the personal jurisdiction of the court. This is usually done just by showing up and defending the case in that court. Now, if they decide to appeal or contest the court's jurisdiction without submitting to the personal jurisdiction of that state, they can. So by showing up to appeal or to contest personal jurisdiction, that doesn't mean that they're subjecting themselves to that state. This is for the defendant. Now, however, a petitioner, by the domiciliary, they automatically consent to full personal jurisdiction by showing up. So that's an important distinction to note. A non-domiciliary can show up to contest the court's jurisdiction. However, the person who is domiciled there will consent to full personal jurisdiction by showing up in court. Substituted service, under some circumstances, is where the state will allow service by mail or by publication in a newspaper. It's sometimes called constructive service. It's an alternative to being personally served and hand-delivered the complaint and summons. Now, long-arm statute, I really wanted to touch on this. If the defendant is a non-resident of the state, the long-arm statute allows substituted service to acquire personal jurisdiction if the defendant has sufficient purposeful contacts with the state. The defendant must have sufficient minimum contacts with the state so that it is reasonable and fair to require the defendant to appear and be subjected to full personal jurisdiction in the state. So what constitutes sufficient minimum contacts to meet this standard? Some examples could be that the defendant was domiciled in the state at one time before he or she left. The defendant cohabited with his or her spouse in that state before the defendant left the state. The defendant visits the state often, or the defendant arranges for schooling for his or her children in the state. Basically, if they have any reason to be protected and to benefit from contacts in that state, they arguably have established minimum contacts. I'd highly encourage you to review Exhibit 7.3, which is the kinds of divorce jurisdiction a court can have on page 263, just to again familiarize yourself with the types of jurisdiction a court can have, how this type of jurisdiction is acquired, and finally what the court can do with this kind of jurisdiction as it relates to family law matters and divorce proceedings. So jurisdiction isn't enough in order to challenge various parts of the divorce judgment. We also have to look at who is challenging the divorce judgment and if they're eligible to even bring this attack. So can the one who obtained the judgment help the other spouse obtain it or receive benefits from the judgment later try to attack the divorce judgment? No, they cannot, as a result of equitable estoppel, which prevents a person from attacking divorce judgment, even though the judgment may clearly be invalid and they benefited from it. Now, what about the person against whom the divorce judgment was obtained? So it depends. Let's say the divorce judgment was granted after both sides appeared before the court and argued their positions. Can either side attack the divorce judgment on jurisdictional grounds afterwards? The answer is no. They should have raised this jurisdictional attack in the original divorce action. Now, what about in an ex parte proceeding where only one side appears? Can the absent party later against whom the divorce was obtained attack the divorce judgment on jurisdictional grounds? Yes. What about a party against whom the divorce was obtained and has already accepted some alimony payments? Can they later attack the divorce on jurisdictional grounds? No, they can't, because they've already benefited from the divorce judgment. Now, what about a person who was not a party to the divorce action? Can a second spouse attack a divorce judgment? The answer is no, because that second spouse relied on the validity of the divorce when he or she entered the marriage and shouldn't be allowed to upset the validity of that marriage by challenging it later on. Now, what about the child of the parties? The child will stand in the shoes of the parent. So if the parents would have been prevented from attacking the divorce on jurisdictional grounds, then the child will also be prevented from bringing up such a challenge. But if the parent would be able to attack it, then the child would also be able to as well by standing in the parent's shoes. So there are two ways to challenge or attack a judgment, either directly or collaterally. It really depends on the proceeding during which the attack is made. So a direct attack is a challenge or attack against the validity of a judgment raised in the same proceeding that rendered the judgment, so basically which happened within the normal appeals process. A collateral attack is a challenge or attack against the validity of a judgment that was raised in a different proceeding from the one that rendered the judgment. Basically after the time a normal appeals process has passed. We're going to talk a lot more about custody jurisdiction within 2 weeks, so we're going to hold off on that, which heavily emphasizes the home state of the child. So as it relates to custody jurisdiction, we're just going to hold off briefly because we'll dive deeper on that issue as we cover an entire chapter on child custody issues. So now we've established jurisdiction. What about the venue? The venue is the place of where the trial happens. The proper county or geographical area in which a court with jurisdiction may hear a case. So for us, our venue would be Ventura County Superior Court if we're in Ventura County. When there's more than one court that has subject matter jurisdiction to hear a particular kind of case, the selection of the court is called choice of venue. Basically, the choice of which superior or county court a party will select to file for divorce. This is really established by statute. So for example, some statutes might specify that a divorce action can only be filed in the county where the defendant's spouse resides, or in the county where either the plaintiff or the defendant has been a resident for 3 months preceding the commencement of the action. So in some states, including California, it's possible to obtain a divorce primarily through paperwork without going through elaborate court procedures. It's often referred to as a summary dissolution or a simplified dissolution. I provided a sample workbook for what needs to be filed, what a summary dissolution is, and what it looks like in California. I'd highly recommend you to look through that. The requirements for taking advantage of this option are usually very strict. So again, a summary dissolution is a divorce obtained in an expedited manner because of the brevity of the marriage. So it wasn't a long marriage. The minimal amount of marital property, they didn't acquire that much property during the marriage, and the lack of controversy between the husband and wife. So this could mean that they didn't have any children, they didn't really have any real property other than perhaps one house, or they just rented their entire marriage, so there was no property. So there are options to have an expedited dissolution, which is known as a summary dissolution. So before I spend too much time on the intricacies of divorce procedure, I highly want to recommend that you take the civil litigation course with Jerry so that you could dive deeper into each of these requirements, which are present in civil proceedings, including divorce procedure as well. So typically, a divorce procedure includes pleadings, which is the petition or the complaint, which asks for a specific relief, which in this case is a divorce. Discovery relates to obtaining any relevant information that would assist in the trial preparation. Also, any information that would be necessary to establish property settlement agreements, which is typically where there's the most discovery, where there's a lot of substantial assets, a lot of accumulated wealth during the marriage, and where a lot of it is contested. So types of discovery include interrogatories, also known as ROGs. Oops, let me go plug in my computer real quick. Depositions, which is where one party questions another or the other party's witnesses, usually happens outside of the courtroom and inside of one of the law offices. Request for admissions, which is where one party sends a request to another that they agree that a certain fact or legal conclusion is true. So basically they're admitting a specific fact, so there's no need to prove it later on. during trial, and then also requests for production when one party requests that another party provide access to documents or other tangible things such as diaries, business records. It could also be a request to enter their property. And then finally, independent medical examinations. So if there's a physical medical condition that's in controversy, one of the parties could obtain a court-ordered professional examination. This could also include, for example, a DNA test or a paternity test. So a pretrial conference is also known as case management or the case management order. It's before the trial begins, where the judge will hold one or more pretrial conferences to narrow down the issues, secure stipulations, establish parameters for discovery, and finally try to make a last-ditch effort to settle the case without going to trial, and also cover any other preliminary matters. So this really acts as the blueprint for what to expect for the case. Some states will have a compulsory waiting period or cooling off period, for example, 60 days. That usually starts to run from the time the divorce complaint was filed. The courts hope that by implementing a waiting period, tempers might cool down and produce an atmosphere of reconciliation between the two parties. Some preliminary orders that can happen pending the outcome of the litigation, or pendente lite, which can also be known as temporary orders, and remain in effect only until final determinations are made later on. So examples of preliminary orders can include the following: granting temporary physical custody of the children to one of the parents who will become the custodial parent and the parent with whom the child is living; granting temporary child visitation to the non-custodial parent or the parent who's not living with the child; granting temporary child support; granting temporary spousal support; granting temporary attorney's fees and related court costs. For example, if one spouse doesn't have the resources to pay for private counsel, but the other spouse does have substantial resources, the court might order the richer party to help pay the other's fees and costs. Stopping the parties from changing insurance policies, granting one spouse control of a business operated by one or both spouses. So these are examples of preliminary orders that could be issued, particularly since divorces can be very time-consuming, and court calendars are often so crowded that it'll take months before the case is heard. This kind of covers major issues that need to be addressed right away while litigation is still pending. Of course, there's a trial, particularly if a divorce proceeding does end up in trial. The trial hopes to resolve all of the divorce-related issues in one proceeding. If there's more than one proceeding that needs to take place, because there's a bitter and complicated dispute over business assets, pension rights, there's a lot of assets that need to be addressed in a separate hearing. This could lead to a bifurcated divorce, where the dissolution of the marriage is tried separately from other issues in the marriage, such as the property division. This allows parties to get on with their lives. So if there's someone else they want to marry, while they have to work out issues relating to their property division. Okay. So inside of the modules, I included a short YouTube video where someone demonstrates how to fill out the standard family law form 100 in California. There you'll be able to see what a standard divorce petition looks like. You'll see the caption is at the top. The jurisdiction and the venue are typically part of the header. The body is the only part of the pleading that contains the main allegations of the parties. The prayer for relief is basically their formal request. In this situation, it would be to dissolve the marriage and perhaps divide marital property. The subscription is a signature. Verification is a formal declaration stating that a party has read the pleading and verifies that it's true to the best of his or her knowledge. And then notarization is to certify or to attest to the petition or complaint. So prior to going to trial, some courts may mandate mediation or arbitration. This could also be included as a clause in their prenuptial agreements or even in their separation agreements. Mediation is a method of alternative dispute resolution in which the parties avoid litigation by submitting their dispute to a neutral third person known as the mediator, who helps the party resolve their disputes. It's important to note that in mediation, they do not render a decision resolving it for them. What they'll do is they'll mediate, they'll draft a memo, basically outlining any agreements that the parties were able to come to during the mediation session and submit it to the parties' attorneys, and the attorneys will then draft an agreement based on the mediation memo. Arbitration is the same thing as mediation, except that the neutral third party renders a decision resolving the dispute. So if there is a clause that requires arbitration between two spouses before they divorce, or it's important to note that that arbitration clause cannot be binding if it relates to child custody or child support issues. Anything that relates to the child has the court has a final say in terms of determining support or custody issues, and they will not enforce a clause that has binding arbitration as it relates to these issues. Other forms of alternative dispute resolution: mediation first, or arbitration second, which is known as med-arb. Private judging, which isn't really private judging at all. It's basically like mediation, but using a retired judge. So arguably they have more experience and also more clout and buy-in from the parties, knowing that their neutral third party has expertise in the field of family law and divorce particularly. And then neutral evaluation, which similarly relies on expert experience from family law attorneys, seasoned attorneys, maybe not necessarily a retired judge. Collaborative law we discussed during the week on ethics. It's a method of practicing law in which the attorneys and parties seek to resolve their family law differences without litigation. To encourage settlement, the attorneys refuse to continue representing the parties if litigation does become necessary. The parties must find other attorneys if the case goes to trial. So in collaborative law, which is present, there are opportunities for collaborative law and family law in California. There are specific organizations that just focus on collaborative law. You'll have an attorney specifically only to represent you and to encourage settlements, but if you ultimately decide as a spouse to litigate, you'll have to find a different attorney. So what happens if one of the parties refuses to adhere to a divorce judgment? There are a number of topics and tools that can happen if someone fails to adhere to a divorce judgment. Civil contempt, which is what most of us know as, can potentially lead to jail time until they do comply with the order. It's important to note that jail through civil contempt is not used if a judgment debtor doesn't have the present financial ability to pay either their alimony or their child support. We'll go deeper into child support in later chapters, but there are ways that people do get around this in saying that they don't have the present ability to financially pay for their awards, but they end up working under the table. But it's important to note that for civil contempt, it can lead to jail time. Execution of a judgment is a command or a writ to a court officer to seize and sell all the property of the losing litigant, basically the person who owes the money, in order to satisfy the judgment debt. Garnishment. The court authorizes the judgment creditor to reach money or other property of the judgment debtor, the person who owes money, in the hands of a third party. So either directly from their employer, wherever they're working, or through their bank that has their savings accounts, separate savings accounts. Attachment. Property of the judgment debtor can be attached when the court authorizes its seizure to bring it under the control of the court so that it can be used to satisfy a judgment and be held as security for such satisfaction. So if the judgment debtor, the person who owes money, owns a really nice car. It can be attached to the judgment order to be held as security to ensure that they do make their payments on time. Receivership, the court can appoint a receiver, which is a person to manage property litigation or in the process of bankruptcy, to prevent him or her from squandering or hiding their property, making it unavailable to satisfy the judgment. So putting it into a third party to overlook their property to make sure they don't try to hide it, to later be used to pay off their judgment. And then constructive trust we've talked about before, where it's a trust is created by an operation of law to prevent unjust enrichment by someone who has improperly obtained property through fraud, duress, abuse of confidence, or other wrongful conduct. So the third party who is asked to hold the property for his or her son or daughter, who is the person who owes money, they later decide to hang on to that property for themselves. A constructive trust would be placed on the property to ensure that that third party doesn't try to keep it for themselves, and instead actually holds on to it for the purpose of forcing that the person who owes money to sell that property and pay off their judgments. So it prevents unjust enrichment of a third party whom the court trusts to hold on to that property simply for the purpose of making sure judgments are paid off. Okay, so in terms of enforcing religious agreements, some civil courts will enforce agreements made within a religion, so long as the court does not favor one religion or over another, doesn't settle religious disputes, and applies neutral principles of law. So this is typically brought up in terms of contract issues. Now, some courts argue that this is a slippery slope and they try to avoid it altogether, but it is important to note that some civil courts will enforce contract agreements specifically that are made within a religion, so long as they don't meddle in terms of favoring one religion over another, settling religious disputes, and again, apply neutral principles of law. And that covers our chapter on divorce grounds and procedure. Thank you for listening.